Sir, I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black room.
Welcome back to one of the wildest legal roller coasters on this channel. Today, we're diving into part 4 of the Frank Mitchell saga, a sovereign citizen case that truly stretches the limits of courtroom patience. If you're just joining us, here's a quick recap. Frank started with Judge Green, was punted over to Judge Oakley, tried to argue jurisdiction, mistrusted everyone, and has now circled back for a preliminary hearing that could bind him over the circuit court. The charges? Felon in possession of firearm, carrying a concealed weapon, and felony firearm. Oh, and he brought the gun to an airport. You'd think this would be an open-end shut case, right? Not when you're dealing with a man who believes the court is a trust and the judge is his trustee. Buckle up, because Judge Green is not playing, and we're about to witness a verbal fencing match between the rule of law and pure sovereign fiction.
210736FY. This is State of Michigan versus Frank Mitchell. May I have your appearances, please?
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
Would you state your name for the record, sir?
My name is Frank Mitchell. I am a beneficiary of the Frank Anthony Mitchell estate that you are administrating over, and I appoint you as the trustee for the record. Let the record show. I am here as making a special appearance, not general. I am here on the duress and coercion.
Thank you, Mr. Mitchell. Today is the day and time scheduled for the preliminary examination. In this matter, there is count 1, weapons, firearms, possession by felon. Count 2, carrying concealed weapon. Count 3, felony firearm. Are the people prepared to proceed?
We are, Your Honor. We do have a couple preliminary matters.
Before we do that, Mr. Mitchell, are you prepared to proceed?
No, ma'am. I'm actually here to get a better understanding of things first before any proceedings.
What is it that you need to get a better understanding of, sir?
For one is the jurisdiction that the court is operating upon.
Judge, I'm going to object. The court has made a decision on this motion previously. Both you and Judge Oakley had ruled on this, so I'm going to object.
Mr. Mohammed, hold on one second. Mr. Mohammed, what we will do is let Mr. Mitchell make his record.
Yes, ma'am. Okay. Constitution, the Sixth Amendment grants me the right to know the nature and the cause of the action. I know the jurisdiction that you're operating upon for the record.
The next thing, sir. The next thing. You said you had some preliminary matters, which suggests more than one thing.
Oh, yes, the jurisdiction of the court.
Part 3 brought the case back to Judge Green, which brings us to today, so let's get started.
Anything else?
Yes.
What's next?
Is this going to be criminal, civil or criminal? And I also want to, with the basis of that answer, I would like to address some other things as well.
What other things, sir?
It's pertaining to off your answer. So,
Mr. Mitchell, I think we had this conversation last week. Correct me if I'm wrong. This is a criminal case. It is alleged that on February 23rd, 2021, at the Detroit Metro Airport, which is located in the city of Romulus, you committed the following: that you did possess and or transport and or purchase a firearm when ineligible to do so because you've been convicted of violation of Controlled Substance Act 333.740124 4012A4, a specified felony, and the requirements for regaining eligibility had not been met. Contrary to MCL 750.224F, count 2, carrying concealed weapon, that you did carry a dangerous weapon, to wit, a pistol, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, to wit, a Range Rover. Contrary to MCL 750.224. Count 3, felony firearm, that you did carry or have in your possession a firearm, to wit, a pistol, at the time you committed or attempted to commit a felony, to wit, felon in possession of a firearm. Contrary to MCL 750.227B, there is also an habitual offender third offense notice on the file where it's alleged that you were convicted of the offense of violation of Controlled Substance Act on October 24, 2013, and convicted of the offense of attempt carrying of a concealed weapon on April 30th, 2002. That being the case, the court having responded to the charges indicated to you that this is a criminal matter, the court's question back to you, sir, is are you prepared to proceed with the exam in this matter?
No. You still haven't stated the jurisdiction.
Here we go again. Frank immediately pivots from a basic yes or no procedural question to a full-on jurisdiction lecture. Notice how he doesn't answer whether he's ready to proceed. Instead, he challenges the court's authority like he's on a YouTube legal forum. Judge Green stays cool, though, allowing him to make his record. This is a calculated patience. You let the nonsense hit the record, then crush it with procedure. But it's only the beginning of today's jurisdictional gymnastics.
Oakley stated that the jurisdiction of the court was Michigan statutes, and that's not what you're saying today.
Chief Judge Brian Oakley, you had a conversation with him about a month ago. We're having a hearing today. And sir, we're doing one of three things today. We are proceeding with the exam, you're waiving the exam, or we're adjourning this matter. Your response to my question right now is one of those three things. What are we doing this afternoon?
And you also stated that you addressed me having questions, and I had another question pertaining off your answer, and I wanted to read that.
Mr. Michaud, no, we're not doing this afternoon. Exam, waiver.
Well, at this moment, okay, since I'm under threat, arrest, and coercion, I would like to appoint Mr. Sullivan as the trustee for them.
The charges are being read in brutal detail, and they're not minor. Frank allegedly brought a gun to Detroit Metro Airport, which alone is a serious federal-level red flag. Judge Green calmly spells it all out, including his status as a convicted felon and habitual offender. But instead of addressing the facts, Frank's about to spin us back into another lecture about legal philosophy, completely sidestepping the real issue. That's a classic SOVCIT move. Argue the court's identity rather than the actual... This is a court. You've appeared this afternoon. This case has been called. And if you're prepared to proceed with Mr. Sullivan sitting to your left, this court will proceed. Is that what you're indicating?
Well, you say I'm not under threat, right? And if I continue to ask a question, I will be held in contempt, which is a threat, right?
I never said contempt, sir.
Well,
What we are is scheduled for a hearing, and what this court does is hearings. And I entertained some of your questions, but it is now 2:15. And the court's, I know, sir, but I'm presuming that there will be some testimony.
Okay, but you're asking me, am I ready to proceed? And while you're asking me, you also telling me that we're about to proceed. So you're not actually giving me the right to answer the question. You also making it seem like you're threatening me. So
Mr. Michaud, I'm interrupting you to tell you that I'm not threatening you.
Okay,
but I've answered all that needs to be answered from this court to proceed with either the exam, a waiver.
Okay, all right. But you haven't answered the questions that I have asked. I said I had another question, and you're still not allowing me to ask the question. So do I have the right to ask?
What's your question, Mr. Michaud?
Okay, I just want to ask you, far as, hold on one second. I want to read this for you.
No, sir. You had a question. What is your question?
Can you help me understand this? Okay, according to 27 CFR 7211, it say all crimes are commercial and must have nature and cause and be prosecuted in the name of the people of the states as a real party in interest, not the people of the state, the corporation, the fiction. This is 20 FCFR, right? So I'll need you to elaborate on this code for me, please, and thank you.
Mr. Michaud, this court will decline to elaborate or respond to that because this afternoon we are here to determine if the prosecution is able to show that a crime has been committed and that probable cause exists to believe that you are in commission of that crime. That is what we're doing this afternoon.
I understand, but it says that possession of a deadly weapon is a commercial crime. So I need to have a better understanding if this is a commercial crime. You said this is a crime and there is no injured party where I hurt anyone. You haven't gave me the right to face my accuser. And it tells me under this code, 27 CFR 72.11, all crimes are commercial. A deadly weapon is considered a commercial crime. So I understand that commercial is civil, but you're telling me this is criminal. So how is it criminal? And it says if there must be an injured party for a corpus delicti for the record, an injured party, and you haven't presented an injured party for the record. So, I mean, can you elaborate on what?
Now, this is a power move by Judge Green. She doesn't let Frank spiral into a monologue. She gives him 3 clear choices: proceed with the exam, waive it, or adjourn. Simple. But Frank won't take the off-ramp. He starts layering more questions, more what-ifs, more imagined threats. His strategy seems less about defending the charges and more about delaying proceedings indefinitely. But Judge Green's having none of it. She gives him space to speak, then steers it right back on track.
Last week and just now, you indicated a right to face your accusers. And you indicated that the court will be presenting something. The court is not presenting anything. The court will take testimony this afternoon and review evidence, documents, videos, whatever it is that either Mr. Mohammed or Mr. Sullivan on your behalf presents to this court. You want the right to face your accusers. I don't know who Mr. Mohammed is calling to give testimony this afternoon. I don't know who, if anyone, Mr. Sullivan is calling to give testimony this afternoon. That being the case, sir, are you prepared to proceed with the exam?
Okay, so the Chief Oakley said that he stated for the record that my accuser was the state of Michigan. And here in this code, it says the prosecuted in the name of the people of the states, not as the people of the state of Michigan. So what he said is contradiction to this code, and it's 27 Code of Federal Regulations 27/7211. All crimes are commercial. So I still I don't understand.
You were in front of Judge Oakley for a probable cause conference, which is basically a scheduling. Are we having an exam? Is there a plea or is there a waiver? For some reason, that didn't happen with Judge Oakley. You then had a PCC with Judge Green. Then you were with me for PCC last week. I asked you questions, you wouldn't respond, but I tried to answer your questions. And the people twice demanded an exam. And when you would not answer my questions, I scheduled the exam. Mr. Michaud, your only response right now is yes or no. Are you prepared to proceed with the exam this afternoon?
Well, under threat and threat, duress, and coercion.
And here's where things really unravel. Frank cites 27 CFR 72.11, claiming it proves all crimes are commercial. The only problem? That code deals with property seized by the ATF, completely unrelated to firearm possession by a felon. It's like quoting a recipe for banana bread in a murder trial. Yet, in sovereign citizen circles, quoting random legalese gives the illusion of legitimacy. Too bad Judge Green reads past the smoke and mirrors like she's flipping through a children's book.
Mr. Michaud's record and Mr. Mohammed proffered to the court People versus Perkins. And Mr. Sullivan, the court has had the opportunity to review the opinion, and it does indicate that the defendant bears the burden of producing evidence to establish that his or her right to possess a firearm has been restored. That being the case, the court is accepting the certified record that was tendered by Mr. Mohammed. The court also has had the opportunity to hear the testimony of Officer Stempian. And for purposes of this preliminary examination, we'll find that the people have met their burden. And we'll bind Mr. Michaud over as charged. Mr. Michaud, your next appearance date will be on March the 13th, 2024 at 9 a.m. That will be at the Frank Murphy Hall of Justice.
Frank takes issue with the label people of the state of Michigan versus the people of the states. This isn't just semantics. He's trying to argue that one refers to a legal fiction and the other to a sovereign entity. In SOVCIT ideology, these distinctions are everything. But here in real court, it's irrelevant. Judge Green, again, keeps her focus razor sharp. Are you ready to proceed with the exam or not? The patience on display is nothing short of judicial endurance training. This is the moment of truth. Judge Green hits back with the facts. CFR 72.11 has no bearing on his case. It's about seized property, not felony firearm possession. Frank has been trying to reframe this entire criminal hearing as a commercial dispute. But in legal reality, if you're a convicted felon caught with a gun in an airport, your sovereign arguments won't fly, literally or figuratively. This is the difference between conspiracy YouTube and actual case law.